Hello, my name is Orlando Conetta from Pinson Masons, where I head up product engineering. I'm also a member of the Lord Chief Justice Advisory Panel on Artificial Intelligence. In this module, I'm going to be discussing the applications for AI in commercial legal practice. Research in AI law has been ongoing for over 40 years, during which time the world has changed beyond recognition with the exponential growth of computing power, interconnectedness, and data. The legal industry has itself advanced, and through several periods of consolidation and growth, many firms have transformed into large organisations that utilise state-of-the-art technologies to coordinate the global delivery of its services. Today, millions are being invested annually into legal tech startups that bring together lawyers, engineers and academics with a hunger to transform legal services for the better. However, have any killer apps in AI emerged from this mashup of talent? Are firms embracing AI as much as the market would suggest, or is it all just hype? It is these questions that I shall seek to address. To appreciate the spectrum of legal activities AI could potentially assist with, this module shall briefly illustrate legal applications across 8 types of human reasoning, divided between analytic and synthetic activities. Indeed, we shall not be interested in the automation of incidental operational tasks such as stationary ordering, but will instead focus on the use of any technology towards the systematization of functional legal activities, like drafting contracts. Through this approach, it is hoped that beyond any example given or vendor cited, you will have a framework against which to think and research about the types of opportunities AI offers, as well as appreciate its limitations. Analytic tasks. Classification. Unsurprisingly, with information being the working domain of lawyers, the industry has historically invested heavily in technologies to assist with the challenge of categorizing information. Platforms like Kira and Luminance are the early pioneers and today's bellwether for the legal tech industry. Both systems are designed to assist lawyers in contractual due diligence and have standard features to facilitate collaboration and reporting for large projects. For our purposes, they also utilize machine learning to automate the classification of documents and clauses under review. For example, highlighting clauses relating to confidentiality, change of control, and so on. Indeed, these systems come pre-trained and ready to tag the most common types of clauses to be examined in diligence exercises, and enable lawyers to focus their efforts on the content that was automatically deemed relevant by the AI engine. The downside is that it is an involved process for a lawyer to teach the system to identify an entirely new class of clause, and relies upon there being a good set of examples for the model to be trained and tested against, a challenge that becomes ever more difficult if one is trying to differentiate similar clauses, such as a change of control which has provisions for consent, against those that do not. Another problem is that the best explanation the system can offer for attributing a tag to a clause is a number representing the statistical confidence that it was correct. While the model used is itself subject to its own confidence score, gauging precision and recall, which is ultimately dependent upon the quality of the original content the model was trained and tested against. Consequently, even where the performance of a specific clause classifier is high, it is a big leap for a firm to entirely trust the output and confidence percentages of automatically applied tags, knowing that they're putting their name into the final assessments they deliver back to clients. Outside contractual diligence, e-discovery vendors such as Relativity and Disco have for many years offered features in predictive tagging, which enables lawyers to automatically apply tags within sets of electronic evidence. As before, users build a model by undertaking manual coding against each document being processed. The greater the number of items manually tagged, the more accurate the underlying model becomes at suggesting classifications for documents not yet reviewed. Unlike contract review, evidence sets are often vast and unstructured, and beyond what a human could ever be expected to read manually. Therefore, the benefits that can be provided through AI-powered predictive tagging arguably outweigh its potential downsides, especially where the granularity of classification is at the level of a document and is not required to differentiate between subtle variations of contractual provisions. Assessment. Returning to the contract review use case, there is a material difference between the classification of, say, a confidentiality clause and its legal assessment against the norms of a particular client. This distinction is reflected in a different set of legal tech platforms focused on contract negotiation, such as LogX and ThoughtRiver. The extent to which these systems guide assessments depends upon the level of investment made towards encoding the contractual playbook of an organisation. At a basic level, it may be that the platform highlights a risk on the mere presence of a tagged clause, simple to implement, but as discussed, less able to provide granular guidance across subtle variations. Alternatively, some firms use expert system technology to facilitate guided questionnaires for expert lawyers to follow in order to determine risk at a granular level. These are very technical questions that could not be completed by the layman and are used to isolate and deep dive on legal points that are in scope. However, for many clients, the need is to enable parties to self-serve and negotiate contractual terms on their own without the assistance of lawyers. And as such, the critical question is how to limit the scope of such systems to the triage and management of easy cases. A non-trivial undertaking that is subject to the open texture problem and is explored through the works of Richard Susskind and others. A fascinating topic that is well worth further reading. Indeed, organisations do often filter easy contract requests on the basis of non-legal factors such as its value and impact. And so it would seem that advanced contract negotiation platforms that delve into legal risks are mostly suited for the triage and management of work between legal professionals of varying grade and experience. Prediction. Prediction takes as an input the current description of a system and generates a new projected state for a future point in time, with weather forecasting being the most obvious example. The challenge with developing prediction systems is in first deriving good, rich data against which AI learning can be applied. Legal tech company Lex Machina originated at Stanford University through collaboration between their law school and computer science department. They have focused on the problem of curating structured data on US patent litigation cases across a variety of inconsistent sources. Through the application of state-of-the-art techniques in natural language processing and data science, they have been able to highlight patterns in decisions that would have otherwise remained hidden and identify the potential relevance of non-legal factors in case outcomes, such as the presiding judge and state. Interestingly, their product is not actually designed to automate case predictions, but instead empowers users to apply their own case scenarios against Lex Machina's rich datasets, so lawyers can configure more informed case strategies on the back of empirical data. This approach can also be seen elsewhere in the use case of matter price prediction, where law firms want to more accurately predict the price of undertaking a new piece of work. Vendors like Clocktomizer and Intap are developing features for law firms to curate rich structured models of their working patterns, all through the analysis of data held within time recording, document management and email systems. Armed with this data, lawyers can themselves develop costing scenarios for a matter based upon the collective experience of the firm. Diagnosis. Where assessment is the process of reaching a decision for the purpose of preventing, mitigating or fixing a known legal fault, diagnosis examines the legal symptoms that have manifested themselves and for which the legal faults are as yet unclear. An example of this type of reasoning being applied by law firms is in the offering of no-win, no-fee case arrangements. Here, legal professionals diagnose the scenario presented, or symptoms, in order to identify potential legal faults, which can then be assessed against relevant facts to decide if the case would stand a fair chance of success. While there are very few instances of automated legal diagnosis systems being applied within the industry, the recent rise of citizen developers and open government are seeding greater opportunities for the democratization of justice through self-service systems. A powerful example of this is the Do Not Pay chatbot system operating in New York and London, and was created in the first instance entirely by a 19-year-old Stanford student, Joshua Browder. Browder's system is designed to diagnose the possible unfair causes for the issue of a parking ticket, and through an interactive question-answer session, filter these possible faults down to a set of valid grounds for appeal. The results really do speak for themselves, and in the first 21 months after the site was launched in 2016, the service was able to process over 250,000 claims, of which 160,000 were successfully appealed. In doing so, the site not only diagnosed legal faults, but directly facilitated the submission of appeals, an entirely different type of human activity that, through action, leverages the objects of analytical reasoning tasks to produce an outcome or object. Synthetic activities. Configuration. Earlier we explored the challenge of gleaning descriptive activity data on matter work for the purposes of price forecasting, and legal processes, like raising parking ticket appeals, involve a variety of steps that are invariably complicated and vary across jurisdictions and circumstances. For this reason, firms have for decades invested in knowledge functions with legal staff dedicated to curating and packaging best practice materials such as checklists and boilerplates, all for different types of legal work. Configuration describes the process of applying such componentized knowledge to new requirements in order to define a plan that is specific to the circumstances the lawyer has been presented with, a challenge that has formed the basis of my own legal AI research, as well as my work at Pinson Masons. Today, most firms already employ some form of semi-automated configuration through the use of document assembly platforms like Thomson Reuters Contract Express. As the name would suggest, these systems assemble a document by running rules to determine those parts that are relevant to the facts of the matter and configure a new document out of those applicable sections. However, this same principle can also be applied across other types of best practice materials. In our research at Pinson Masons, we have applied techniques inspired by ontological modelling so as to define libraries of frameworks across the different types of work we undertake. An individual framework is controlled through a hierarchy of legal scenarios that determines what parts are relevant for a particular matter, which is classified using information provided by lawyers through dynamic questionnaires. Within an employment tribunal template, for example, there will be sets of questions and content relevant where the claim is for sexual discrimination, while other parts will be pertinent in claims for racial discrimination. And what is configured is a plan of activities, along with templates, guidance and workflows, which leverages the scaled operations of the firm against the conditions unique to the instruction. Scheduling and assignment. For any project plan, it is necessary to allocate various activities to groups of people and resources, and brings together two closely related types of tasks, scheduling and assignment, which both apply constraints to the respective allocation of people, resources, and time to plan tasks. Again, this is an area where we are seeing new project management tools seeking to partially automate processes. Intab, for example, applies natural language processing to classify the experience of lawyers within a firm and build up a recommendation engine relating lawyers to types of legal work. Yet it is arguable as to whether traditional law firms can readily apply planning technologies which are best suited to the control of self-contained, predictable and measurable service teams. Indeed, while much has been done to unpackage legal services and better embed project management disciplines, most firms are still organised around the practice group model. For this reason, it may be that pioneers in process control will be seen outside legal practice and amongst alternative legal service providers such as Elevate and United Lex, who structure their organisations around multidisciplinary teams that are focused on serviceable jobs to be done. Modelling. Our final category of task is by far the most complex for computer systems to automate, and is the perfect prism through which to highlight the limitations of AI technologies in a practical context. Modelling is the process of automatically generating an abstract and structured description of a real-world thing or event, which, as you can imagine, is not trivial. To illustrate the state of the practical art, I shall split my focus on the application of modelling for transactional contracts and dispute cases, respectively. Starting with the former, we have already explored how classification enables us to apply tags to clauses. However, a system that could truly model a contract would produce a far richer description than simple clause tags. For example, a model of a loan agreement would go on to describe the parties, payment schedule, key dates, hedging provisions, and indeed all of its other facts and obligations. All to such a degree of fidelity, the computer would be able to actually simulate the operation of the contract by applying scenario data against its software model. While lawyers manually need to perform that level of analysis daily, it has not yet been possible to develop platforms that could reliably produce such models automatically. Returning to our first task, it is not possible to automatically classify legal provisions without first developing a taxonomy of classes that a contract or clause could potentially be associated with. To solve this problem, vendors and firms are applying algorithms to cluster content within sets of contracts for which there is no prior knowledge. These programs run recursively in order to identify the optimal and most accurate grouping of content against sets of clauses within contracts, which can then be labelled and organised within a taxonomy for use in classification. There are various clustering techniques, however, what they all have in common is a notion of distance that can describe the extent to which one cluster is different to another, which invariably focuses on either clustering by topic or expression. In the latter case, for example, similarity is determined by the number of additions and deletions that would convert one contract or clause into another. Exactly like the comparison lawyers use every day to redline differences between contrasting drafts of a contract. When taken as a distance score, it is possible to then identify clusters of documents or clauses that share the same expressive form, and therefore could be assumed to be based on very similar styles or standards. Another example of technology helping with contract modelling is in the utilisation of natural language processing frameworks in the extraction of facts like named entities, dates, and places. These tools do not link extracted objects against their respective subjects in the document. That would need another layer of processing to parse relevant phrases and sentences. Indeed, anyone who's used tools like Google Assistant and Apple's Siri will quickly appreciate the limitations of the technology to parse structure and meaning from complex sentences, let alone understand the interplay between clauses that make up a complex contract. There has been progress, but it is still way short of a human. Notwithstanding these limitations, information extraction makes it possible to enrich search and other forms of data analysis. Lawyers can extract coarse information across batches of historical agreements and combine them with the results of other analysis, such as clustering, to create models that guide the efficient review of similar sets of terms, ensuring lawyers are not analysing the same standard terms within a set over and over again. Moving on to the modelling of dispute cases, we presented earlier the example of predictive coding to facilitate the review of very large evidence sets for litigation. Separately, tools have been marketed, like CaseMap by LexisNexis, to help litigation lawyers manually model a case for the purposes of developing a unified view as to its relevant questions, issues, and facts. Alas, as with contracts, there are no automated means of developing comprehensive case models. However, e-discovery vendors with specialisms in AI are now extending further into case management and offering tools for at least the semi-automated abstraction of facts. Email analytics, for example, enables lawyers to automatically generate a timeline and conversation view of vast email stores, which can then be filtered, tagged, and bundled more easily. This is still a long way from complete model generation. However, arguably, automation is missing the point. Maybe the value to professionals is in the provision of tools that support in the application of their own human expertise when modelling a case, such as, for example, building timelines through effective and collaborative platforms. Indeed, whether it be modelling, prediction, or classification, this similar pattern emerges, that the value proposition for most applications of legal AI are less about automating people and more about gaining and leveraging deep insight into the legal activities they perform. On that basis, and from our examination today, I hope that you would agree that AI does not offer any quick fixes. Instead, it is a broad toolset that enables us to do the hard work to better understand the legal system we serve and empower our professionals to deliver the rule of law in the 21st century.